call Marshall County Fiscal Court to order July 18th, 2017. We're going to get right to business with Sharkow Bridge. The bid, we've got Sean Miller here from DLZ. We're going to go through that, and then we'll give them the material. Wendy and Sean can go review that bid, and we can move on, try to save some time.
I got the advertisement here. It was ran in the Tribune on July 15th and, July 4th and 11th. Invitation sealed bids for the construction of the Sharp Calvert City Road over Little Cypress Creek Bridge replacement project received by Marshall County Fiscal Court at Marshall County Road Department, 160 Homer Lucas Lane, Benton, Kentucky 42025 until 4 p.m. local time on July 17, 2017 for furnishing all labor and materials, performing all work as set forth by this advertisement, conditions, specifications, and/or drawings prepared by DLZ Kentucky Incorporated, 201 Brighton Park Boulevard, Frankfort, Kentucky, 40601. Bids will be opened on July 18, 2017 during the fiscal court meetings. And then there's a list of specifications in the advertisement. One bid was received on July 17, 2017 at 327 by Jim Smith Contracting. Lump sum total is $397,515.65. And there's a bid estimate with a list of all of the item descriptions.
Wasn't a sealed bid. We just wanted to make sure.
No, I didn't. That's the only thing.
I think Wendy may have it. There was another company that they faxed it in. It didn't meet the bid. Wasn't sealed or anything, so it didn't meet the bid specs.
From who? Who was that from?
There was a, which one, the actual bid?
I just understood there was two bids.
No, there was one.
Oh.
There was a fax that came in it didn't meet the bid specs.
From who?
I just want to let, she's going to.
Oh, okay.
I just want to let y'all know that, so that if you get contacted by anybody, it didn't meet the bid specs. Okay, they're going to go look at that. We'll move on. Approve the minutes for June 27th meeting.
Motion to approve.
Second. Second. All those in favor say aye. Any opposed? Motion carries. The TVA easements, I know, Dennis, originally we had discussed that, but do y'all want to discuss that? They did change some language in it. Does that meet the?
Well, it's better, and Jason and Jeff and I have talked about it. It's better, it's not perfect, but it gives us a little shelter, I think.
Okay.
And it's still more or less take it or leave it. Of course, we have quite a bit invested in it, so.
Right.
I don't think it puts us in a great deal of risk any more than we already are, and I think Jason and Jeff would concur with that.
Okay. We had last talked about the easements. Basically, there was some legal question or wording, and TVA responded. Basically, they added.
It's in bold, to the extent permitted by law. That's what they put.
So in other words, they didn't come off their,
No, they still want the provision in there, which we don't.
that's the way I interpreted it.
Right, but, I mean, it helps a little bit.
It's probably somewhat of a minor miracle that they changed that agreement.
Yeah. We did get some movement, but not. But the question that
Because you're talking about a gigantic federal bureaucracy that changed one of their standard form agreements.
Yes.
Just think about what that entails.
And that, you know, it's eight short years.
How many government lawyers do they have to talk to do that?
Yeah. What brought this to discussion was that we needed to sign the easements. So with that change, we need to,
This mine?
that's for y'all's review.
Oh,
Just
okay,
to
this
see it.
one, about one.
We can let Jeff look at it that way. We would need a motion for me to sign that, the TVA easement.
Motion to approve your signature on the TVA
Second.
easements.
All those in favor say aye. Aye. Any opposed? Motion carries. This is the one, Jeff, that was faxed to us. Rick, you want to talk about the drainage project at Retirement Circle?
Yeah, I'd be glad to, I guess back in March of 2016, that's not when we started, but we got an agreement with a property owner in a drainage project at Retirement Circle where we were going on private property. After they started the project, they came to me as commissioner in that district and asked if I knew the property owner who had the 40 acres that would help alleviate some of the drainage problem in addition to the private property we were already going to be on. And the property owner agreed, and they went in and cleaned out the ditch, and the project is the people are tickled to death at Retirement Circle, the success of the program and to our county road department. But when they got ready to put the soybeans in this time, that 40-acre field, that where they cleaned out the ditch was the crossing where they put the farm equipment, and it's a matter of us coming in. So we have identified, Roy Watkins and Wendy and I have identified a culvert that we dug up on Greggstown School Road when we were repaving that and changing out the culvert. So we're using a used culvert. We're going to drop that in there and put it back as the memorandum of agreement stated, to make the property back to the conditions it was before the drainage project started. So we've got a used culvert that we just need to get court permission to proceed.
Jeff, do we need to do another memorandum of agreement since the time it was over a year?
All we're doing,
If it's the same
yeah,
property, I wouldn't
it
think.
just
You
says,
don't need it? Okay.
it just in number 3 under in the agreement, it just says we'll put it back the way we found it, and obviously they've got to get across the combine's got to go across a 40-acre field the other end to get to the other 20 acres on the other side. It just splits that 40 acres, so it's, you know, very little expense there because it's a used culvert to go in there and do that.
Is there a motion?
Approved, placing that used culvert in.
Second.
Second. All those in favor say aye. Aye. Any opposed? Motion carries. Next is the agreement with Code Red. We had looked at several different companies, but this one seemed to be a little bit more detailed. This agreement is an annual payment of $12,000. The capabilities that it gives to the residents in the community is we can give them notifications. I know we're emergency management, 911, all the agencies really can utilize Code Red. We can give them immediate notifications if there's emergencies within the county. One that comes to mind is the rainstorm or flooding that we had last year. Some of that information, if those citizens would have been Code Red members, we could have notified them immediately of some of the road outages, and definitely could have prevented some of the issues that we had. But this is a good, I know Calvert City has Code Red. They adjusted their contract. They were originally going to use all county residents. We explained to them that Calvert City has Code Red already, so they made some adjustments. $12,000 annual cost is actually a pretty good cost for us to get this service. As you can see, it has quite a bit of assets to it. What I like about it too is that you can do your management on it. For an example, if you've got men out on the street, you can notify your people that are out on the street. You can isolate that notification directly instead of just doing a mass notification to everybody. If it's something that's going on in the south end of the county and there's people in the south end of the county that are into this program, you can single those individuals on the south end of the county. If it's a water boil, there's notifications that we can give specific to the parts of our county instead of just doing a mass notification.
As you said, Judge, Calvert City has been contracted with Code Red for several years, and they're tickled to death with the service they provide. And you kind of answered the question that I had about the, because when we were talking to the Code Red people, that they weren't making concessions for Calvert City already being in the program, and when they sold the program to the city of Calvert City some 6, 7, 8 years ago, whatever it was, that the county was present at that meeting, and they were talking about the combined savings, and Calvert City didn't want to wait to pull the trigger. They thought with the plants, they needed immediately the service and opted to go ahead, although the county did not get on board at that time. So, but I'm glad to hear that they made concessions, so.
Yeah, there were several requests. I know there were at least 2 regarding one lady's got an infant child, and there was a water boil in the district that she was in, and she didn't get the notification. She expressed interest if we did have something of a service like this, that she definitely would be a member. One of the things that we're going to have to do if we do take on this agreement is we're going to have to work with the citizens in the community, that if they want to sign up for this, because there are going to be some citizens in the community that aren't going to want to have that notification sent to them. But there will be some work on our end to make sure that we try to notify everybody in the community that if they do want to participate, they have to give us their information and we can add them.
Yeah, well, it's very important through the press or whatever means to educate the public, because the program does not work at all. It's zero or near zero unless the public's educated.
We just need a motion if we want to accept this contract.
So moved, Judge.
Is there a second?
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries. Dennis, are you going to
I
talk?
guess, well, one thing we need to be sure we get out, folks, is that this won't be shared and then their numbers won't be shared in any way. I think that's what bothers people about sometimes giving their information, but it won't be shared in any way except in this system. So hopefully people will sign up. If they don't, then it's, like Doc said, it won't be useful at all.
Right. Are you going to talk about the comprehensive engineering plan as far as what you went and saw and?
Judge, I have provided for everyone, just a summary of my observations, from, I have seen various projects that each of the engineering firms, have done. And, the unfortunate thing about that is they all do very good work. I say unfortunate, that's a good thing for us. I've been across the state, been to Missouri. Again, I've summarized what I've observed. And I think each of the firms has representatives here today in case anybody wants to ask them any questions. But at this point, where we are is that I think we need to sit down with each firm individually to discuss, basically, to kind of narrow down what it's going to cost for them to provide these services as far as designing the comprehensive plan. And I don't know that they have answers for that today, but we did invite them here because we want them to hear what's going on. That's sort of what my recommendation would be, is that we set up a time to just sit down with each one and say, and make sure that everybody understands exactly what we want. Their statement of qualifications, each one checks out out very well. And they have, each one has comparable projects that will fit in, and there's no question, any of the three firms can do the work we're seeking. And I hate to not be able to make an absolute recommendation.
Sure.
But when you come right down to it, a lot of it's gonna boil down to, at this point, who can give us the best for the best price.
Now, when you say we, you
I
talking about
say
the
we,
fiscal
you're talking
court?
the
Okay,
And, I'd like to, obviously, I'd like to sit in on it,
sure.
since I will be directly involved. But I think that's what we need to do at this point before the court can make that decision.
Would that be, could we accomplish the same, to sit down with each, with the park board since,
Well, we could, yes.
then,
Either way would be fine.
okay. Set a date, that way we can all sit down. Any comments on that?
If we do it the way you suggested, Dennis will be involved, because he's part of that process with the
I would
four people that
suggest-
make the recommendation.
I would suggest, if we do that, that we not do that, immediately after a court meeting, set a separate date to do that.
Sure, I agree.
That way then because I think it's something that will take, a good portion of time.
Do you want to coordinate with the three, and you might be able to resolve that today? I think they're all here, but
Okay?
if not, if
Will that
they're
be all right
not,
with you all? I can, is there anything that, well, Judge, do you all want to hear from any of them right now while they're here, or do you want to just go ahead and coordinate a time?
yeah, I'd say go ahead and coordinate it. That way they got their individual time with them.
Okay, are there any dates that won't work for you all?
I mean, what are you thinking about? There's dates that won't work for me,
Right,
yes,
exactly.
for everybody, I'm sure.
Well, it might be best if you figure that out.
Okay,
That way collectively, we can all kind of put our dates out there through an
Okay.
email or something, and, because I'm sure, make sure that they can be here as well.
okay. I'll get 2 or 3 dates from them,
Yeah.
and then coordinate with you all.
That'd be perfect.
Okay, very good.
And part of that presentation, I'd kind of like to see cost estimates. They may be ballpark. Sorry, bad word, use of word there, but just something that we can talk about and compare.
Sure. All right, good. I think you did that intentionally. All right. We'll move on. I did get the grant application from the Marshall County Exceptional Center. One thing that I want to express on this is that the one thing that administratively that we wanted to accomplish was to quantify those dollars for the nonprofits. And I think the application process is a great start. The application that we got, their needs, we all support our nonprofits in the community. But more importantly, you know, the Exceptional Center provides a service to its students and the adults in the community that has a need to most. It's a service that some of those students and adults, we don't know what they could do without that service. So this application that was submitted, it's $30,600 for general operations. And I think it's important that we support the Exceptional Center because of the service that they provide for those families, those students, and the adults that go there. You know that we set our rate, or our amount, $30,600 is more than what we had set. But I'll be the first to say that I will support going above that, and I'd even go as far as to say I'll make the motion that we draw the additional monies from the reserve so that we can provide the financial support to the Exceptional Center through this grant application.
That's a motion, Judge.
That's a motion.
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries. All right, we'll go with new business.
Judge, I have one item of old business.
Yes.
Yesterday, Wendy sent me a proposed contract regarding the construction project out at the road department. And the contract was sent to us from Glen Harris Construction Incorporated. I've looked at that. I think do you have a copy of that?
Yes, it does.
I do.
I looked at that yesterday afternoon, and there are at least 2 or 3 provisions that I just don't, I can't in good conscience agree to. Section 15 provides that in the event there's any litigation, the unsuccessful party will pay the other party's attorney's fees. We can't agree to that because CAECO will not pick up a breach of contract claim. That would fall on the county attorney's office to defend that, and we wouldn't have any attorney's fees. It would be us. So we're facing all the risk there. So we cannot agree to that. I also do not like the Section 20 deals with the binding arbitration. Arbitration in lots of cases can be more expensive than litigation, so I can't agree to that. The other thing that bothered me, find it here, was Section 11. It's basically not really a statute of limitation, but it says that he corrects things that appear within 1 year of the date of presenting. So if, in other words, what that says is that any problems that may arise have to occur within 1 year. If they're a year and a day, something goes wrong, then contractually he could be off the hook for it. So those are 3 and there's some other cosmetic changes that I would like to see changed in here. But what I've told Wendy is that he can, or she can, provide Glenn with my email address. I'll send him the changes that I would like to see made, and if he doesn't agree to those, then my recommendation would be not to sign this as is.
Sure.
Unless these changes are made.
No, I think that's good for you guys to review that. I know Jeff and we briefly talked about it yesterday, or actually Friday, or yesterday. But I think that would be a good idea. If you want to draft that, let's see, we meet August 1st, so.
Well, he sent this to us in PDF. So what I'm going to have Wendy is just give him my email address. I'll email him changes to make to the document. And if he agrees to them, great. If not, then we got to go back to square one. So.
Okay. All right. Under new business, nuisance board appointment, Coy McCurry. Now, there's 3 members to the nuisance board. We've got 2 presently. I know Hardin has their member. Ken stepped down and left open a position on the board. At the end of this month, actually in 2 weeks roughly, Coy is going to be a retired employee of the county. So with this appointment, I would say that effective August 1st, that way he's not a county employee, but that would be my appointment to the board.
Motion to approve Coy McCurry's appointment on August 1st.
Seconds motion.
All those in favor say aye. Aye. Any opposed? Motion carries. The Code of Ethics Board appointment, there's 3 members. We appointed 2. The 3rd member, my appointment would be Lisa Mellies.
Who are the other 2 members?
You've got Richie Clenenden and Joe Frizzell.
Okay, yeah, that was last meeting, okay. I have no problem with that. So moved.
Second. All those in favor say aye. Aye. Any opposed? Motion carries. Jonathan Creek Water District Board resignation and appointment. Mark Holt sent his letter of recommendation, or letter of termination, or resigning, June 28th to the Fiscal Court. I am writing this letter to inform you that I'm resigning from the Jonathan Creek Water Board effective immediately. Thank you, Mark Holt. To replace and complete his current term, I would make a board appointment for Mike DeBolt. You should have a letter. Was there a letter, his background attached to it? You didn't put, okay.
It is in there? Okay.
I'll read it. I asked him to put together
Get a copy of that, Des.
his experience. Dear Kevin Neal, I'm proud to submit a brief synopsis of my experience prior to my retirement last week. This to be shared with other members of the community at will. My 51 years of experience include, however, were not limited to planning, design, development, and construction of manufacturing, chemical, power generator, water, and sewer treatment facilities. Over the last 6 years, I've been the site manager for American Municipal Power Company at Smithland Hydroelectric Project, responsible for design, coordination, budget, construction schedule, and coordination of all trades relative to the $1.2 billion project. Other features include the development and construction of a 62-well dewatering system capable of delivering 72,000 gallons per minute on-site sewage and potable water systems. Previous to this project, I was a site manager on projects nationwide, such as the Toyota Tundra project in San Antonio, Texas, the Toyota KY-OHO project in Stockton, California, the Shintech chemical plant project, Baton Rouge, Louisiana, and Goodyear tire plant in Fayetteville, North Carolina. In previous years, I was also the lead block layer in the Jonathan Water Treatment Plant, lead contractor on concrete pumping for Tilford Mechanical and Reedland Treatment Plant, masonry contractor on the City of Benton Water Treatment Plant, and lead contractor on their Tilford contract on the Perkins Creek Lift Station. It would be my honor to share my experience for the betterment of our community. That's sincerely Mike DeBolt. Does anybody know Mike? I think you might know his daughter.
Yeah, I'm thinking I do. I'm trying to place that.
I think he said, you probably know him. You probably, like me, you got to see the
Got to see his
person.
face.
Yeah.
Yep.
But he definitely has the experience, and he doesn't live that far from the Jonathan Creek plant.
I would move to appoint Mr. DeBolt to the Johnson Creek Water Board.
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries, and I'll have Des get you a copy of that.
Judge, would it be a good time to clean up the other appointment that I read a statement from Barry Hill at the last court meeting, and he no longer wishes to serve, and as allowed by law, I would like to rescind my vote in favor of Jeff O'Brien to clear that up,
I think
breaking a 2-2 tie.
I think the statute already did that after the 15 days.
Jeff is a member now. Okay.
Okay. Yeah, I have no problem if that,
Be a
but
good
it is allowable by law within that procedure.
We've got bid advertisements for 2 3/4-ton pickup trucks for road department.
Yeah, we'll be replacing 2 other 3/4-ton. I just need permission to advertise for the 2 3/4-ton, and the next one is the 1-ton pickup that pulls the patcher.
So there'll be 2. Do you want to combine that in one motion?
Yeah.
I'll make a motion that we go out for bid for the trucks. 2 3/4 tons and a 1-ton to pull the patcher.
Second.
All those in favor say aye. Opposed? Motion carries. Ordinance 2017-08, speed limit on Marco Street, first reading.
Be it ordained by the Fiscal Court of Marshall County, Commonwealth of Kentucky, in accordance with the provisions set forth in KRS 189.3905A, and based upon the request of affected citizens after review by the Marshall County Road Superintendent, the Marshall County Fiscal Court does hereby set the speed limit at 25 miles per hour for Post Oak Lane and Tillett Hill Lane, located in Marshall County, Kentucky. And this is the second reading on this, first reading, this, the July 18th, 2017.
Do you want to do the first reading on ordinance 2017-09, speed limit on Post Oak Lane and Tillett?
That was that one.
See, that was
the
09.
That was 09, okay.
Oh, okay. Now I'm going to 08.
08, okay.
Be it ordained by the Fiscal Court, Marshall County, Commonwealth, Kentucky, in accordance with the provisions set forth as in KRS 189.390, 5A, and based upon the request of affected citizens and after review by the Marshall County Road Superintendent, the Marshall County Fiscal Court is hereby set the speed limit at 25 miles per hour for Marco Street located in Marshall County. As first reading this July 18, 2017.
And then we've got the ordinance 2017-10, the fog amendment, first reading.
This is an amendment to the existing fog ordinance, and what Jeff gave me, my understanding is that I don't think what I'm getting ready to read includes the changes that we made at the last meeting, correct? So we'll have those additional changes for the second reading. All right, so I'm just gonna start here with what we've added to the existing ordinance. This is entitled Section 16, Specific Pollutant Discharge Limits. General conditions. The following described substances, materials, waters, or waste shall be limited in discharges to the Marshall County Sanitation District Number 2 sewer system to concentration or quantities which will not harm either the sewers, wastewater treatment process, or equipment, will maintain and protect water quality in the receiving stream, and will not otherwise endanger lives, limbs, public property, or constitute a nuisance. The executive director or his or her designee may set additional limitations or limitations more stringent than those established in the provisions below if, in his opinion, more severe limitations are necessary to meet the above objectives. Informing his or her opinion as the acceptability of a discharge, the executive director or his or her designee shall give consideration to such factors as the quantity of subject waste in relation to flows and velocities in the sewers, materials of construction of the sewers, the wastewater treatment process employed, capacity of the wastewater treatment plant, and other pertinent factors. B, restricted discharges. Any garbage that has not, subsection 1, any garbage that has not been properly shredded. Garbage grinders may be connected to sanitary sewers from homes, motels, institutions, restaurants, hospitals, catering establishments, or similar places where garbage originates from the preparations of foods and kitchens for the purpose of consumption on the premises of when served by caterers. 2, any wastewater containing toxic pollutants in sufficient quantity, either singly or by interaction with other pollutants which injure or interfere with any wastewater treatment process, constitute a hazard to humans or animals, causes the MCSD number 2 to violate the terms of its KPDES permit, prevents the use of acceptable sludge disposable methods, or exceed the limitations set forth in a categorical pretreatment standard. 3, any radioactive waste or isotopes of such half-life or concentration as may exceed limits established by the MCSD number 2 in compliance with applicable state or federal regulations. 4, any water or waste which by interaction with other water or waste in the public sewer system release noxious gases from suspended solids which interfere with the collection system or create a condition deleterious to structures and treatment processes. 5, waters or waste containing substances which are not amenable to treatment or reduction by the wastewater treatment processes employed to the extent as required by MCSD number 2 KPDES permit. 6, waste or waters classified as a hazardous waste by the Resource Conservation and Recovery Act without a minimum 60-day prior written notifications of such discharge to the executive director. Such written notification must include the name of the hazardous waste, the EPA hazardous waste number, type of discharge, volume, mass of discharge, and the time of occurrences. Executive director or his or her designee may prohibit or condition the discharge at any time. 7, wastewater identified as causing, along or in conjunction with other sources, the POTW treatment plant effluent to fail a toxicity test. 8, recognizable portions of human or animal anatomy. 9, any waste containing detergent, surface active agents, or other substances which will cause excessive foaming in the MCSD number 2 sewer system. Number 10, any waste or water which have characteristics based on a 24-hour composite sample grab or a shorter period composite sample if more representative than exceed the following maximum domestic wastewater parameter concentrations. A, BOD 300 parts per million, TSS 350 parts per million, NH3-N 25 parts per million, oil and grease total 200 parts per million. Any person discharging wastewater exceeding the maximum allowed concentration as noted above will be subject to a surcharge for each pound loading over and above the set limit. Any other amenable constituents requiring that addition of specific chemicals for proper treatment will also be subject to surcharge as noted on the discharge permit. Exceeding the effluent limits specified above shall not be deemed to constitute a violation of a permit condition of this ordinance if the appropriated surcharge fee is paid and the discharge does not cause interference or pass through of the POTW. 11, the following limitations are established for characteristics of any wastewaters to be discharged into MCSD number 2 sewer system. All significant industrial users must comply with these limitations where they are more stringent than applicable state and/or federal regulations. Arsenic, 0.30 parts per million. Cadmium, 0.08 parts per million. Chloride, 10,000 parts per million. Chromium, 0.70 parts per million. Copper, 1.30 parts per million. Cyanide, 1.10 parts per million. 0.03 parts per million. Is that?
We'll have to confirm that.
So there's a safe level of cyanide, I guess.
Absolutely. It's in peach seed.
Lead, 0.23 parts per million. Mercury, 0.02 parts per million. So you can have more cyanide than you can have mercury. Nickel, 1.90 parts per million. pH, 5 to 10.5 units. Silver, 0.80 parts per million. Zinc, 1.70 parts per million. Number 12, the MCSD number 2 has received authority through the U.S. EPA and state statutes to enforce requirements of 40 CFR subchapter N, 20 CFR 403, and 40 CFR Part 35. Accordingly, in addition to the requirements set forth above, all users shall comply with the requirements of those regulations. C, dilution of wastewater discharge. No user shall ever increase the use of processed water or in any way attempt to dilute or a discharge as a partial or complete substitute for adequate treatment to achieve compliance with the limitations contained in the categorical pretreatment standards or in any pollutant-specific limitations developed by the MCSD number 2 or the state. D, protection from accidental and slug discharges. Each significant industrial user shall provide protection from accidental and/or slug discharges of prohibited materials or other substances regulated by this ordinance. Facilities to prevent accidental or slug discharges of prohibited materials shall be provided and maintained at the owner's or user's cost and expense. Once every 2 years, MCSD number 2 will determine whether each industrial user needs to develop or update a plan to control slug discharges. If MCSD number 2 determines that a slug control plan or revision is necessary, the plan shall contain the following: A, description of discharge practices. B, description of stored chemicals. C, procedures for notifying the POTW. D, prevention procedures for spills. Number 2, in the case of all actual accidental and/or slug discharges, it is the responsibility of the user to immediately telephone and notify MCSD number 2 of the incident. The notification shall include location of discharge, type of waste, concentration and volume, and corrective actions. 3, within 5 days following an accidental and/or slug discharge, the user shall submit to the executive director or his or her designee a detailed written report describing the cause of the discharge and the measures to be taken by the user to prevent similar future occurrences. Such notification shall not relieve the user of any expense, loss, damage, or other liability which may be incurred as a result of damage to the POTW, fish kills, or any other damage to person or property. Nor shall such notification relieve the user of any fines, civil penalties, or other liability which may be imposed by this ordinance or other applicable law. A notice shall be permanently posted on the user's bulletin board or other prominent place advising employees whom to call in the event of a dangerous discharge. Employers shall ensure that all employees who may cause or suffer such a dangerous discharge to occur are advised of the emergency notification procedure. E, state requirements. State requirements and limitations on discharges shall apply in any case where they are more stringent than federal requirements and limitations or those in this ordinance. F, MC SD number 2, right of revision. MC SD number 2 reserves the right to establish more stringent limitations or requirements on discharges to the POTW if deemed necessary to comply with the objectives presented in this ordinance. G, categorical pretreatment standards. Upon the promulgation of categorical pretreatment standards for a particular industrial subcategory, the standard, if more stringent than limitations imposed under this ordinance for sources in that subcategory, shall immediately and automatically supersede the limitations imposed under this ordinance. That 16 was what was added to what we already had. We'll have the other changes next reading.
I got one question. The fog ordinance, we've got, it's a county ordinance, we got 2 districts. Do we want to make this specific to District 2, or do we want to reword that to where it's covering both District 1 and 2?
Yeah, it should be.
It
Cover
should
both
be.
of them.
It should be.
I made a note, so when we meet, we'll just meet.
We'll change that, yeah.
Yeah, countywide.
Yeah.
I know we had a meeting yesterday with some of the businesses. We contacted the businesses in District 2. 3 showed up, but it was an educational meeting to educate them as far as the BOD levels and the fats and the grease. Just to give you an idea, we put a lot of time and energy and resources into this. Yes.
The private wastewater treatment plants in the county, or is it just the public wastewater treatment plants?
The public.
The ones held out of the county?
The 3 showed up out of how many?
But it was an educational meeting to, educate them on where we were last year and where we are today. Just to give you an idea, we had samples just randomly taken in the district, and if you see what's being recommended here with the BOD levels and the fats, oils, and grease, these levels, I think it's a lot easier to understand when it has 300 or 400 for a BOD, and a BOD basically is your oxygen-depriving substances. The plant is actually designed to work at 300 to 400. You exceed 300, 400, it doesn't matter. The bugs are arriving dead. We can't produce, or we can't process anything. The BOD levels, we've had some levels at 2,500. If you look at the oil and grease, 200 parts per million. In some cases, we've had levels at 1,600. So what that says is we can actually, last year it was the mechanical piece of the plant. We got the mechanical piece fixed. Now we're in the biology of it. At these levels, we can't keep anything alive in the plant. So we've got to put this in place. And this isn't just Marshall County. This is across the country. These standards are already set in place. So that's the main reason to be putting these levels into this ordinance. We're going to send out another letter to the businesses to explain to them what came about from our meeting. I know Johnny was there, and it was actually the businesses that were there, they actually left understanding what the issues were. So this is just another step forward in getting in compliance with the district.
I had 2 of those contact me last night, asking if we could get a contract from, I think we touched on this, on AAA, for instance, and Lane's Mobile John bid on the pumping, where they can get them a fixed rate and know exactly what it's gonna cost them, maybe a 1-year contract.
You talking about the businesses getting a contract?
Yes, with whoever bids the pumping.
Yeah, I think we talked about that, and I think there was interest for the businesses to go in together to put out a bid or try to get a contract to make the few businesses that actually do pump their grease traps more competitive. But I think that would be at the business level. Because that is a concern for, you got some companies that don't fall in this parameter, these levels. We don't want to use a blanket approach to where if there's a business that's out there utilizing good business practices, and they're well within or below these levels, then they're doing what they're supposed to be doing. And the health department was present at the meeting. They're going to tie that into the educational piece when they actually do their food service training for the required training that they're supposed to do, because this is good information that they can pass on to those that work in the food industry, that they're not dumping grease down the drains, or they're not, whatever the practices may be, that they're doing proper practices within the restaurants and businesses. All right. New business, county clerk's claim for calculation of motor vehicle and boat bills for 2017. We just need a motion for that.
Accept.
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries. Under new business, Capstone HR Services Incorporated Consultant Agreement. Last year, I sat down with Capstone. One of the things that we intended to do was to actually have job descriptions laid out for the county so that we have a consistent job description identified for our positions. I know we kind of started with the road department. Wendy and I, we sat down, and she did a great job of putting something together. We had discussed it during our budget workshops, but having a third party come in and sit down with the department heads, and this is what Capstone does. They actually, I think they've done work for McCracken County and the city of Benton as far as identifying job descriptions and in some cases wages, so that we can get our administrative process across the board, our HR in place consistent. So this is a contract. They'll come in. We're going to have them sit down with the road department first, since we already kind of put something in place so that they can review that and get that started. But this is just a contract with them.
What is the cost to the county for the service?
I'm sorry?
The cost to the county taxpayers for this service?
Well, you got their rates. I would say the cap, we budgeted a cap, so the cap is budgeted.
Compensate, there you go.
Is there any questions on this agreement?
This will be $250 per job description, but we don't have a number. The number of different descriptions they'll be going over.
I would say roughly less than 17.
Less than what?
17.
17.
If there were 17, that would be 4,250. Is this 4,200, it says plus 4,200 for the work associated, is that, so it's 8,000 total?
If you look at the Section 3 compensation, consideration of consultant services, client shall pay Capstone the sum of $250 for each job description drafted as part of Phase 1 work, as listed in Exhibit A. Exhibit A is on the back. Plus $4,200 for the work associated with Phase 2, as listed in Exhibit A, plus any additional monies as provided in Exhibit A. Client shall pay such fixed sum to Capstone at such time as identified on the fee payment schedule attached as Exhibit B. In the event client fails to make any payment when due, client shall pay 12% annual interest on any unpaid portion, plus any cost of collection, including but not limited to reasonable attorney fees. But if you look at what we budgeted X amount of dollars. So that's why I'm giving you an approximate on the job descriptions, because we got to stay within that budgeted amount. Is there any questions on the agreement? Is there a motion?
I guess what may have created the necessity, we don't have job descriptions
We-
at this point.
Yeah,
don't
we-
have any.
We don't, and the other issue, when you look from and Brad, you may, from an HR standpoint, having Capstone come in, we could sit down and do it, but you've got a company that this is what they do. They know the federal laws, the state laws, and it's a third party coming in and doing this instead of us sitting down and doing it. But it basically makes a consistent job description. When you have an employee, when you're talking about career development, and I get hired into the county, well, I need to know what my job is. I need to know what the expectations are. And laying this out explains to not only the employee, but that relationship between the employer and the employee, what the expectations are. And then if there's career advancements, it also lets the employee know how to climb the ladder if they want to advance their career. So putting this in place is just the first start to make that a lot easier for everybody to understand, because we've got inconsistencies across the board. If you're an employee and you got somebody working beside you that's making more money than you, and you question why they're making more money than you when you basically perform the same task, I think it should be our due diligence to lay that out, what the requirements are. So this is the first step to do that.
Not something we'd want to bid, I don't guess.
It's under 20, and it's,
I didn't know if there's any other, I don't know of any other, but the job description issue, certainly, I understand it, that's, at the plant, we have to have job descriptions. It's
Yeah.
actually, I'm not exactly certain all the details, but it's certainly, I think it's actually something that relates to our OSHA standards and regulatory standards.
the Capstone, like I was saying, they just completed work for Benton, doing the exact same thing. Actually, Exhibit A was almost somewhat similar to what was presented. and they did some work for McCracken County with their administrative code. The judge executive there wanted to see if they were following their administrative code, and Capstone came in, evaluated it, and came back and gave them a report in each department, which departments were following their policies or the administrative code, and they just cleaned it up. It really is, from an HR aspect, it's an advantage to have somebody come in that they actually know the federal and state laws, and they can create that document for us.
Could we do this next meeting, and maybe we could contact some of the folks, if they've worked for Benton, and we at least get to talk to them about if they were satisfied. I really don't know anything about this process.
Well, when we discussed it, now, I don't have a problem with that, but when we discussed it in our budget, the road department, there's already a template with the road department, and there's men down there that are waiting for us to take action on this, because it's going to affect them directly.
Remember me talking in the budget meeting about implementing a pay scale change for the men based on what they can do? We put that in the budget, to change the pay out there, but we're unable to do that till we do something like this.
I sense there's some hesitation here. Is there some concerns?
It says the client shall reimburse Capstone for out-of-pocket expenses such as office supplies, travel, meals, lodging, and other necessary expenses, which,
My only question would be to the other, if we could just maybe have just enough time to speak to some of the folks that use them, and let, if they've done them a good job, then I wouldn't have a problem with it.
Yeah, I mean, I've researched it and sat down with Capstone last year. We actually had prepared, we even sat down, prepared, we looked at the road department, especially because at the way we had it, when you got hired at the road department, you got the same rate as the next person that works beside you. But there were certain job descriptions within the road department that Wendy had identified to where if there was an incentive to get the employee to, we have a minimum standard that's required. There's nothing wrong with that. The employee is hired, he knows what the minimum standard is. But then if there are certain certifications that they may get, if I'm an employee, Wendy's an employee, and I come in and I meet the minimum standard, but then she goes and she gets the certification, she starts trying to do that career development so that she's more marketable as an employee. At the end of the day, we still get paid the same. So eventually what happens over time is she's going to stop going and getting the certification, and really there's nothing to give employees that want to do more than what the minimum standard is. Now, we can sit down and we can create that, but it's best if you have an organization like Capstone that they come in and they do that for us. And in some cases, it helps us because then Capstone is the one that's created that for us. From a HR perspective, this is actually what's needed. We don't have anything in place. And I've been in a position where I've worked and I see where the career development ladder is. And if I want to have the initiative to climb that ladder, it's on me. But if I also see the people that are working around me that don't have the initiative, they want to come in and do their minimum standard, that's fine. But I think we need to spell that out so that all the employees and the administration understands what the expectations are. simplifies it, it quantifies the raises that we give to our employees.
Understood. I'd have no problem acting at the next meeting, just having a little time to review.
That was my concern also. That's the first time I've seen this contract, and I don't think August 1st is be ample time for me to act on it.
That's fine. I just want to reiterate, we discussed this at the budget meeting. We actually put that in the budget. So this isn't something the contract may be new, but
That's
it's
what I'm
not new
referring
to the
Understood.
discussion.
I'm not opposed to the process.
I'd just love to talk to some of them, make sure they're getting the bang for their buck, just make sure they're satisfied.
That's all.
Okay, we'll move on. Encumbrance report.
Our June 30th, 2017 fiscal year ending encumbrances were $5,870.38 for the general fund, $13,636.86 for the road fund, and $10,393.43 for the jail fund, for a total of $29,900.67.
Motion to accept the encumbrance report.
Second.
All those in favor say aye. Any opposed? Motion carries. Appropriations transfer.
We have a few appropriation transfers with insurance purposes. It's moving from they're both within departmentals. It's within fringe benefits and the judicial center. Those two changes, they balance out to zero.
Motion to approve the budget appropriation transfers.
Second.
All those in favor say aye. Any opposed? Motion carries. Intra-fund transfer.
I will be moving from health spending account to the building inspection fund, a bank-only transfer of $439.60. And then two from the occupational tax fund, one to general fund for $1 million, and one to the 911 fund for $80,216.50. Both of those are budgeted transfers.
You said that 1 million, just real easy. Motion to approve transfers.
Second.
All those in favor say aye. Any opposed? Motion carries. Treasurer's report.
June 30th, 2017, we had a book balance of $937,011.26. Road fund, $855,390.75. Jail fund, $212,394.18. Grant fund, $410.96. 911 fund, $30,929.81. Occupational tax administrator, $4,956,340.27. Veterans van fund, $3. ABC fund, $65,583.16. And building inspection fund, $33,661.50. Total reporting funds is $7,091,724.89.
Motion to approve the treasurer's report.
Subject to audit. Second.
All those in favor say aye. Any opposed? Motion carries. Treasurer's quarterly report.
Since this is the end of the fiscal year, I'm going to read this one a little bit differently. In fiscal year 2017, the general fund had a total receipt of $9,669,534.91. We dispersed $8,732,523.65, leaving us a cash balance of $937,011.26. Road fund, we receipted $4,527,029.20, dispersed $3,671,638.45, with a cash balance of $855,000. $390.75. The jail fund receipted $2,409,186.93 and dispersed $2,196,792.75. The grant fund receipted $410.96, dispersed $0, has a cash balance of $410.96. The 911 fund receipted $864,483.90 and dispersed $833,554.09 for a cash balance of $30,929.81. The occupational tax administrator receipted $5,055,750.81 and dispersed $99,410.54 for a cash balance of $4,956,340.27. The Veterans Van Fund receipted $7,512.82 and dispersed $7,509.82 for a cash balance of $3. Alcohol Beverage Control Fund receipted $329,242.67 and dispersed $263,659.51, leaving a cash balance of $65,583.16. The building inspection receipted in $282,765.31 and dispersed out $249,103.81 for a cash balance of $33,661.50. Together, all of these match your treasurer's report total of $7,091,724.89. I would add to that we processed a total of 17,622 disbursement transactions. 11,359 of those were accounts payable, 5,774 were payroll, and 394 were expense transfers, and 95 of them were amendments. We had 2,079 receipts receipted in. Our total receipts, including our carryover, is $23,145,917.52, and our total expenses for the year are $16,054,192.62 for the year.
Motion to accept the treasurer's quarterly report, subject to audit.
Second.
Those in favor say aye. Aye. Any opposed? Motion carries. Treasurer's settlement.
This is treasurer's settlement for June 30th. This summarizes your revenue by source per fund. This is basically a restatement of all the things that I just stated, so I'm going to spare you all me repeating all that. However, the document will be on the website for review of anybody that would be interested to inspect it.
Motion to accept the treasurer's settlement, subject to audit.
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries. Approve payment of the bills.
Motion to pay the bills, Judge.
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries. I just want to make sure I announce the ordinance, the second reading of the ordinance 2017-08, 09, and 10 will be August 1st, 2017. And then Wendy's ready for the bridge bid. Does it meet the?
Yeah, I
bid shown
recommend
there?
that we accept Jim Smith contracting bid. It met all the requirements.
Is there a motion to accept Jim Smith contracting at $397,650,
397,515.65.
Is that a lot less than we anticipated?
Yeah, it's a really good price.
I mean, significantly better than we anticipated, isn't it?
Is there a
Yeah,
schedule for the
but you've
work?
got to add on the engineering fees
I understand that.
to all that too. But
Understand
yes, it's a good price.
schedule for work? Do they, I didn't,
I think the easements are the only
Gotta
thing
get-
we're waiting on.
Gotta get the easements.
I think they'll do it though.
Yeah.
Weather's still good. Motion to approve or accept the bid for the bridge.
Second.
All
Jeff,
those in-
I got a question, legal question, I guess. You're okay with the other bid that came in that Desiree showed us? It was,
Yeah, it
wasn't a sealed bid and
Yeah,
wasn't,
it didn't comply with the requirements of the spec.
Right.
I just,
The one from E&H Bridge? Yes, we bid a concrete structure, this one's a steel structure.
oh, okay.
And it was faxed in and not sealed, and he
Right.
didn't pick up any bid specs prior to bidding, so.
Right. I understand all that part. It's just significantly lower than the other bid, but I didn't understand that part
Right.
of it. Okay.
All those in favor on the motion that was on the table? Any opposed? Motion carried.
Judge.
Yeah.
One thing, I know we had a workforce, or a work-ready meeting this week, and we were talking about a presentation on a status update on where we're at with work-ready and moving forward, what things that we need to accomplish. We would like to set a presentation on August 15th after court, to have it in front of the commissioners and also on camera so that we could put it out there for our citizens to know. So I just wanted to ask if that's okay with you all, we'll put that on after court on the 15th.
I've got executive session land acquisition, but with the numbers, after talking with Wendy with the numbers, I don't think it's gonna matter as far as discussion. I think we can probably discuss that now instead of going to executive session. Ridge Road.
Yeah.
I mean, I just throw that out there. I mean, the amounts we're gonna be
Ridge Road.
budgeted for anyways.
So it's not gonna be needed?
Well, yes, if it's done, I mean, if we can get it done in a timely manner, I mean, because we're at the point where we're gonna be needing the fill.
We
There's
infringing on
a-
the property owner's rights if we don't go into executive session, but it's in real estate hands, so we wouldn't be doing that, would we?
No, I mean, this would be a purchase of a piece
Of property, yeah.
Right, I understand.
I
I'm
mean,
familiar with it.
We've
don't
already
know if
got a
there's-
budgeted cost for the project, which is gonna be less than what the property value is.
Oh, I see what you're,
So it's not gonna, anything we discuss shouldn't change the posted value. I mean, that's where I'm saying,
I mean, I just don't know what the sale price might be.
We discussed, it's not gonna change the sale price.
I mean, it's gonna hurt them, I would think. Because we've got a,
Presuming sale price would be the value stated by the PBA.
no, they've got to post it for sale.
Oh,
I mean, it's in real estate, so I don't know.
okay, I didn't realize, I must have missed that. I didn't realize that. I just didn't, you know, and the only thing it could affect is if there is some negotiation room. If when it's talked about, then that would probably be non-existent.
That's my concern also.
Just throw it out there. We can do it. It don't matter to me. I'm just throwing it out there.
I think they should,
Y'all
just to make sure everybody knows what's going on.
Go ahead.
Go in executive session. Okay.
Make a motion, go in executive session.
There's a second. All those in favor say aye.
Aye.
Any opposed? Motion carries. We'll go ahead and call
Thank you, Desiree.
Fiscal Court back to order. The county's gonna make a, offer, on a piece of property, we've got a deadline, since there is a road project involved. We should have the deadline on the 28th. So if we don't hear back on or before the 28th, then we're gonna move forward with the original project, but we are gonna make an offer on the property. We need a motion, for me to make that offer and sign if we do on the 28th. And I think appropriations transfer.
Make a motion, Judge, allow you to sign on the negotiated price by the county judge, or county attorney, and, transfer whatever funds necessary.
Second.
All those in favor say aye.
Aye.
Any opposed? Motion carries. I'll make a public announcement this Saturday at the American Legion Auxiliary on Highway 95 between Calvert Drive-In and North Marshall Middle School. And it's going to be actually July 20th and 21st from 9 a.m. to 4 p.m. Homemade fried pies for sale. So they're going to have peach and apple, $2 each. Come by and get a delicious treat. I'll be going by and getting an apple pie. So, I think that's all I've got, so.
I've got one more announcement for, an audit trail purposes. The auditors ask us to, even though the fiscal court has no say over elected officials' employees and how they use their dollars that are budgeted to them, the auditors would want us to start reading into record any pay changes. The sheriff had someone leave at the judicial building, one of his court security officers. So he is raising Mike Wyatt to 75 cents an hour, with a promotion to corporal.
And then Dennis, you've got some dates
Yes.
with the engineers?
Yes, Judge, we had 3 dates, and I'll go in order of preference. First one is August 7th.
Is this 3 dates for all of them?
No, we're gonna do all of them on one date.
That's what I
But I
meant.
had 3 dates that all of them could be here.
I'm assuming we're gonna meet and then stagger their times?
Yes,
Okay,
yes.
perfect. I'm good on the 7th.
August 7th.
It's a Monday.
I'm good.
Yeah, me too.
Yeah, me too.
What time?
We can, what Brad and I were talking about, maybe staggering them like 8:30, 9:45, and 11 o'clock.
Yeah, that's fine.
And that, give an hour for each, and that'll give us a few minutes between each one, and then we can,
Yeah,
Is that gonna be enough? Hour between?
Are we going to make a decision? We
Well-
just told them that we're going to put a dollar figure to.
well, I mean, but I think that we, if we're ready, if we feel like we have enough information to make a decision, I think we certainly can.
Without a dollar figure?
No, I think they're gonna
No,
present a
I
dollar
think,
figure.
Oh.
yeah, we'll want,
Yeah.
I mean, yeah,
Oh,
yeah.
okay.
So-
We'll communicate to them that we want a dollar
Yeah.
figure, make them have a presentation, and any questions during that time.
Yeah.
Yeah.
So,
why don't
this is
we,
gonna be an official meeting of the,
Park Board Foundation,
okay,
Not the court.
not the court.
right.
then the
No.
official would be the 15th, the following
Oh,
fiscal
okay.
court meeting?
Okay.
Right.
I thought
Okay.
you meant you're gonna decide on the 7th.
No,
Not the,
Well-
not the fiscal court.
Right, the court will have to decide, you're right.
yeah, you all will need to well, if you're,
Be a special meeting of the park board.
and then the park board will make a recommendation to you.
Yes,
Right,
which is,
yep, that's, right. So August 7th is good,
yes.
okay.
And we're going to start the first one at
8:30.
8:30.
Like I said,
Bring
we're
the
8:30,
donuts.
Can you
9:45, and 11
send that
o'clock.
out there, buddy? The request.
And
All right.
we'll do that here, correct?
Do that here.
All right, very good.
Okay. Now I think we're ready for a motion to adjourn.
So
Good
moved.
adjourn.
Second. All those in favor say aye. Any opposed? Motion carries.